Mr. Chair, for the opportunity. Mr. Chair, I would like to speak to Clause 3 because there has been a lot of interest in the purpose of this bill. And this clause, Mr. Chair, forms the basis of this whole bill. And there has been a lot of discussion from both sides about the objective of this bill. Mr. Chair, the objective of this bill is to track serious child sex offenders. And yes, I have heard members from the other side saying there is no evidence saying that this register is going to help us reduce offending or re-offending. But Mr. Chair, to me, it's a common sense thing. Keeping track of serious child sex offenders cannot go wrong. Mr. Chair, we live in a society where the safety of public is of utmost importance. And we also know that the rights of victims are important, but we need to balance the rights of victims with the rights of the offenders. And Mr. Chair, this register is to collect information, not just as a data collection exercise, but the information that will be collected on this register will form the basis for risk assessment for these offenders by police and corrections. The information that will be available on this register, Mr. Chair, will be only for specified agencies and will be available to third parties if required. Mr. Chair, to the SOP from the member from the New Zealand First, Derek Paul, I want to say that I oppose that SOP, Mr. Chair, because there is no evidence that making such a register publicly available helps. It's publicly available register. That is about publicly available register that is not going to help. And Mr. Chair, the evidence clearly shows that making such registers publicly available actually does not provide anything in terms of public safety. Instead, it can disrupt the life of the offenders to the extent that they can take up re-offending. Mr. Chair, that is a very, very narrow focus in that SOP because that SOP is just taking into consideration the offender, but is not taking into consideration the wider picture, especially people, those who can be related to that offender, how their family and work life will be affected if that offender's name and information is in public domain. So, Mr. Chair, it's not just about protecting the offender's information, it's not just protecting victims, but it's also protecting people, those who are related to those offenders, those who will go on that register. And as I said, the information will be available to specified agencies, and based on that, they will be doing risk assessment and they will be able to take preventative action. So, Mr. Chair, I fully support that this database should remain as a secure database, and that is why, Mr. Chair, we want the administration of this database to be so strict. The bill clearly specifies that the administration of this register will be done by the Commissioner. And as we heard before, that before making any significant operational changes, the Commissioner will be required to consult with the CEO of the Department of Corrections. And we have taken this approach, a very, very strict approach, Mr. Chair, exclusive approach, just to ensure that this database remains secure and that public have the confidence in this register. And Mr. Chair, we know that there is a lot of information that will be collected on this register. We need to be sensitive to those offenders and especially the families of the offenders. And about who will go on the register, again, this legislation is very, very clear. People, those who will be convicted and will be sentenced to imprisonment will automatically go on this register. But in case of a non-custodial sentence, it will be the sentencing judge's discretion to decide if the person should go on the register or not. But again, Mr. Chair, this bill gives enough guidance to the judge about who should go on the register. It clearly states that if there is a continuous risk from the offender, then that person should go on the register. So it's about, Mr. Chair, reducing the possibility of reoffending by serious child sex offenders. And about the age, again, there is no uncertainty in this legislation. It makes very, very clear that the person should be 18 or over at the time of committing the offense, at the time of getting convicted of a qualifying offense, at the time of being sentenced to imprisonment, or through non-custodial sentence directed by the judge to be on the register. Mr. Chair, another good thing about this legislation is this, that it covers people, those who are convicted overseas. So people are convicted of a similar offense in overseas jurisdictions. If they decide to come to live here in New Zealand, they will also go on this register. Mr. Chair, about the information, yes, we heard a lot of information will go on this register related to the offender.
Mr. Chair. Lose the wall.